Thank you, everyone. Welcome. Welcome to the Town Hall on Changes to Regional Center Hearings and Appeals. We're really happy to have you. We are expecting a very large turnout. Over 500 people have registered. So I'm sure a lot of people are going to be joining as time goes on. We are a group of organizations that came together to ensure that the new rules around fair hearings and the appeals process are implemented in a way that is going to really be helpful for people to have a fair hearing. Many of you know that there was a law passed last year through the budget process to change the way the appeals process works. We're really grateful to the Department of Developmental Services for working so closely with us to get this law implemented, and you're going to hear from them later on in this presentation. So now that a bunch more people have joined, I'm going to say once again that we're going to be presenting today in both English and in Spanish. So even if you're an English speaker, it is really important for you to select English as your language. You do that by going down to the bottom of your Zoom screen, seeing the little globe that's called interpretation, and selecting either English or Korean. And as you see, we are also offering ASL interpretation as well. So thank you all for joining us, and we're going to get started right now. We're recording this, so if you miss any parts of it, we will be sending out the recording to all those who are registered and putting it up on our website, as well as hopefully in our partners' website. So who is here today? This event is co-sponsored by a range of advocacy organizations. They include my organization, Disability Voices United. I am Judy Mark, and I'm president of the organization. You're going to be hearing from a whole range of folks who are representing these different organizations today, and they will introduce themselves at the beginning of when they first speak. And that includes Public Counsel, the Legal Aid Association of California, Disability Rights California, the Integrated Community Collaborative, and the Stanford IDD Law and Policy Project. So thank you to all of our co-sponsors, and thank you to DDS, who is joining us today. So we're going to get right into it. First, I'm going to hand it over to Miguel Lugo, who's going to tell you a bit about why the hearing process was even looked at. Go ahead, Miguel.
Yes, thank you, Judy. Thank you so much. Good evening, everyone. My name is Miguel Lugo, and I went to a so-called fair hearing a number of years ago. I hired a lawyer out of pocket to go with me to every meeting with the regional center. And definitely I would bring a lawyer to fair hearings because my regional center always had one. I felt intimidated and uncomfortable at the hearing. I remember being anxious about it. My lawyer told me to stay quiet unless I was directly spoken to. I did win my case, but it cost me thousands of dollars to get the services that I knew I was entitled to. And I, unfortunately, am not the only one. Yes. I would like to introduce Evelyn, who is a parent of a regional center client who went to a fair hearing. She will tell you how she felt.
Es como que vas a la batalla contra un monstruo, ¿no? Tú tan pequeñito como mamá y el centro regional ya sabíamos quién te iba a ir con un abogado, ¿no? Entonces, te sientes con una desventaja terrible. Es como que
And here's another example from a mother named Lulit.
He shut me down like right away. He told me you're not supposed to talk, but I only said one thing, one sentence for the whole 4 hours. They were talking that the whole time, but they said something and I said like, no, they didn't. And he was very upset because I spoke up that one time. He shut me down.
And finally, here is Margot, who actually won her case, but still had problems.
When the Regional Center notified me that they were going to stop funding for my sister's services, we took the matter to a fair hearing. The judge did rule in our favor. However, the Regional Center refused to comply with the order. I reached out to both the DDS and to the administrative law judge. Both told me they couldn't help me. Eventually, the Regional Center did comply, but we spent $20,000 of legal fees from my sister's special needs trust for $10,000 worth of services.
Thank you so much, Miguel. And that really puts a human face on why we're here. So I wanted to now present Elizabeth Gomez, and who you should introduce yourself before you present these next slides. Thanks, Elizabeth.
Hi, thank you, Judy. My name is Elizabeth Gomez, and I am here because I have two beautiful boys. One of them is a Regional Center client, and I'm also the director of the Integrated Community Collaborative, home of the Community Integradoras. And our protocol is to hold hands with the community and be able to navigate the complicated systems. And we've been doing this for the last 5 years. And this has brought me to where I am here today. I think that for the last 4 or 5 years, we have been calling the fair hearing process in the community known as the unfair hearing process. And one of the reasons why I think today is very important is because as we review some of this like testimonies like the ones that we just heard from Lulit, from Margot, and from Evelyn, and from many more, I think that our voices were heard. And so one of the things that I like to do is kind of go over some of our experiences, which are very similar to what you just heard. And the regional centers were represented by lawyers at taxpayers' expense. But how this affected us for families, and especially the families that we hold hands with and navigate the regional center system, is that we always felt that nothing that we could do to even help or support them if they did not have the funds or the money to pay for an attorney, they actually did not have a chance during these unfair hearings. They felt that there was no balance in the room. Most of the time, the regional centers always side with the, or actually ask the regional centers lawyers or even the experts that were attending for information about what was being discussed, like for example regarding decisions or notices of actions that families received. Most of the time when the judges had a question, they always asked the attorneys or they asked the regional center for more information. So that also made the families feel like this was not balanced, and it was not, they did not feel that they were being even heard at that time, because they were really always in the hands of the regional center. And the people that they serve and the families were also told that they could not bring supporters to the hearings. This reminds me, in many of the hearings that I attended, we wanted to stay and support the families, and we were asked to leave. the families felt that by not having at least a circle of support, they didn't have attorneys for the most part, and they did not have any other legal representation, but to have them also not have a circle of support or somebody like a community advocate to stay with them was very hard for them, because it left them with absolutely no one. Sometimes the families that we support also need interpreters, and the interpreters sometimes may not be interpreting or translating correctly. And so the families without a circle of support could not have someone that could actually help them in understanding whether what they were saying was being interpreted correctly or not. So this was also a huge disadvantage. Is there some, can you give me the next slide, please? So as we experienced them, the hearings were very, very formal. So they were so formal that it made everyone feel very uncomfortable. I could say that in most of the hearings that I help or attended with many families, not only they were formal, but they were very intimidating. If the judge would not allow the families to speak, they were basically, just felt like you were in a court and there's nothing you could say, or there's nothing that you'd say that would be appropriate. We're always told that, that you needed to stay and wait for your turn. And so these hearings were extremely, extremely formal that made families many times feel very anxious. A lot of them said they were very nervous, and they were scared. So, and for a good reason. The hearing officers asked the regional centers for help, like I mentioned before. So this was very much how it felt, that whenever there was a question, even if it was that relating to the reason for why the family was there, the question was always asked to the professionals or the attorneys and not the families. And even when they tried, they were not really heard. And most people dropped out before the hearings even started. What that really means is that a lot of the families that we would talk to, they would attend probably an informal meeting, and then right after that, they would decide that this was just too intimidating and too difficult, and they did not have a chance. So the paperwork was complicated. The putting the paperwork together was very complicated. So a lot of them felt that it was better to just drop out of the process. And even if it meant not having the services that their family or loved ones really needed. This was very heartbreaking to see, because we know of a lot of families who really needed the services, and they decided not to pursue the hearing. The process, very difficult for anyone. And I would say that if you could not afford a lawyer, the process was not only just difficult, but at the same time, it felt very humiliating at times. And so it made it very difficult for families to feel that they could have a chance. So I can say that I have attended numerous of these hearings, supporting and helping families. And I think that I also felt that the process was very difficult. We did the best that we could. We supported in the best way that we could, but it's still, the process was very intimidating. These are just some of the examples, just like also, the comments or the experiences that you heard from the videos just a minute ago. But I think that we feel that one of the reasons why this is now a reality for us is because the community came together and families did express their concerns. And this is really the result now of all this hard work. So very happy to be here. And my share was just to talk about the past, but hopefully looking forward to what's coming next. Thank you.
Thanks, Elizabeth. I just want to tell folks, I'm sorry to interrupt for a second, how you can ask questions. We're not going to be stopping in the middle of our presentation to answer questions, but at the end of the presentation, you can ask questions in 2 different ways. Number 1, you can use the raise hand feature, which you can find at the bottom of your screen by checking on reactions. You can also ask your question in the chat, and we have staff who are monitoring the chat and will ask your questions at the end. So thank you. So now I'm going to turn to Allison Marantz. Allison, please introduce yourself before presenting.
Hi, my name's Allison Marantz. I am the director of CIDLAP, which is the Stanford IDD Law and Policy Project. And I'm also the mother of a teenager served by San Andreas Regional Center. And I just want to very briefly show you some numbers to make a little bit more concrete what Elizabeth Gomez was just talking about. Remember, she said that most people dropped out of the process before they actually went to fair hearing because it was really intimidating and they didn't feel that they had enough information to really present their case effectively. So you see that here. If you look at the second line or the third line down, the 71, almost 72% of cases were withdrawn. This is the period between 2018 and 2021. So that just shows you that most people didn't even go to fair hearing. We don't know why, because DDS didn't collect any information on why they withdrew. But the concern is that part of the reason that at least some people withdrew is they didn't feel that they had a chance. And that's one of the things that, that this legislation is designed to change. The other thing I want to highlight here at the very bottom of this table is that only a very small percentage of people that actually went through the full process that went to fair hearing actually won, about 5%. The granted, that second to last line, means that they won completely, and split means they won partly. They partly got what they wanted, and that's only about 5%. So there again, that's of concern. You know, if only 5% of people that start the process to go to fair hearing actually succeed, it raises the question of whether it's a fair system. And so these are just some numbers to make that more concrete.
Thanks, Allison. So now we're going to look at the changes that are coming, some which already took place, and you'll hear about them in October, that took place last October. You're going to hear about them as well, but new changes that are coming in less than a month. And I'm just going to spend a second to say that we thank you, the community, for having these changes take place. It was groups like the Integrated Community Collaborative and Elizabeth Gomez who brought these concerns to the attention of the Department of Developmental Services, who then really became involved in trying to get these changes made. It was also the community, all of you, who brought it to the attention of advocates like myself and people at DRC to make sure that these changes went into place. And then finally, when we had legislation last year to try to get these changes into law, hundreds of you wrote letters, made phone calls, testified at hearings. And so I'm taking this moment to say that your advocacy matters. And this is an example of your advocacy at work. So stay involved, and we have lots more changes ahead. So I'm now going to hand the next slide over to Shannon Cogan. And Shannon, please introduce yourself first, please.
Sure. Thank you, Judy. Good evening, everyone. I'm Shannon Cogan. I'm an attorney at Disability Rights California. I lead a program there called the Office of Clients' Rights Advocacy. I'm also the mother of a person with developmental disabilities, which is why I do the work that I do. So I'm going to talk to you about a couple changes that are taking effect on March 1st. The slide in front of you says all appeals will be filed with DDS instead of regional centers. So the appeal just means the fair hearing, right? It's the appeal for the hearing. So right now, when you disagree with a regional center decision, like the regional center says, oh, you're not eligible for services, or we're going to change a service or deny a service, you fill out an appeal form and you give it to the regional center. And then the regional center sends the form somewhere called the Office of Administrative Hearings, or OAH. So OAH is part of the state. It's an organization that has hearing officers. They're called administrative law judges. And they are the people who listen to your evidence and they make the decisions. And so OAH makes all kinds of decisions, like special education cases, and they also make decisions about regional center appeals. So the important change here that happens on March 1st is that when you want to appeal a regional center decision, you're going to send the form directly to DDS, to the Department of Developmental Services. And then DDS will send it to both the regional center and to OAH. And that means that DDS will have information about every appeal that is filed and can sort of keep track of things and spot trends. And that's really important. And I think people have indicated they feel better sending the appeal to DDS than sort of getting confused in communications with their regional center. So the second change that I want to talk about, the slide in front of you says you'll have more time to decide whether to ask for a hearing. So this also, these changes take effect on March 1st. When the regional center is going to deny a service or change a service, it should send you a notice. That's called a notice of action. And right now, once you receive that notice, you have 30 days to ask for a hearing by filling out the appeal form and sending it in. And also right now, if you're getting a service and the regional center says, we want to stop the service or we want to change the service, maybe reduce your respite hours, for example, you have to do something within 10 days. You only have 10 days to fill out an appeal form and say you want to keep your services going. You might know that as something called aid paid pending. It means when you have a service that's already in place, the regional center wants to change it or end it, you can keep that service in place while your appeal goes through the system. And 10 days is not very much time. So right now it's 30 days to request a hearing, but only 10 days if you want to keep your services. So the first change is that you will have 60 days to request the hearing, so twice as much time. And then the second change is that instead of those quick 10 days to keep your services, you'll have 30 days to ask for that hearing and keep your services. And that's good because it gives you more time to think about what's going on, to ask for help in figuring out what you should do next. And more time means there's less chance of missing a deadline and losing your chance to say that you disagree.
I was muted, sorry. Thank you, Shannon. I saw a question in the chat that people want to get a copy of these slides. Definitely, we will do that for you. We will email the link to this entire event, as well as a copy of the slides to all the people who registered for the event, and also get it up on our website and with our partners as well. The next slide is Will. Please introduce yourself and go right ahead.
Well, thank you everyone for being here today. My name is Will Miner. I'm an attorney with Disability Rights California, and I'm also the brother of someone who receives services from San Andreas Regional Center. And I'm going to talk about how disputes will be easier to resolve through what's called mediation. Sometimes the best way to resolve a case is to not go to hearing at all. We're all trying to make the hearing process fairer, but that doesn't mean you'll always win. So under current law, if you want to resolve a disagreement before the hearing, there are two options: informal meetings and mediations. Informal meetings, based on our experience, they're usually done in a way where you're trying to persuade a regional center decision maker to change their mind. It can sometimes feel very one-sided, and this is because in many cases, you do all the talking and the regional center just kind of listens, and there's no real negotiation, and the regional center makes a decision. Oftentimes you'll disagree with that decision. But mediations are when a person called a mediator, who is not part of your case and cannot take sides, helps you and the regional center reach an agreement. Under current law today, the regional center has to agree to an informal meeting if you ask for it, but they don't have to agree or take part in mediation if they don't want to. But with the new laws starting on March 1st, regional centers must now also agree to mediation if you ask for it. And this is a good thing. We find that disagreements are usually easier to resolve when someone else is there to help you and the regional center look at new or different solutions to an issue. And I'm now going to talk about how it will be easier to get more time to prepare for your hearing if you need it. Life can be stressful, right? You've got work, maybe health issues, childcare, drop-offs. Maybe you're trying to figure out what to do if a service provider doesn't show up, and sometimes it's all the things all at once. And then pitting a regional center appeal on top of that, well, it can be a lot. It can be a lot. The current law says that if you need more time to prepare for a hearing, you can ask for more time. We call this a continuance. But you can only get more time if you have a good reason. This is sometimes called good cause. For example, you may have to show that there's an emergency, or one of your witnesses for the hearing isn't available the day of the hearing, or someone in your family is very sick. But with the new law starting March 1st, your first request for more time for a continuance will automatically be granted. You don't have to have good cause, but any additional request after the first request, it won't automatically be granted. You'll need to have a good reason. I want to note one more thing. If you ask for a continuance, the hearing officer will also get more time to make a final decision. So if you have an urgent need for a service, think really hard about if you really need more time to prepare. And again, if you decide you do, well, that first continuance, that first request for more time will automatically be granted.
This next slide is going back to Allison. Go ahead, Allison.
Hi again. So this is one of the most important parts of the change that is happening, and it's actually already taken effect. It took effect in October of 2022. Remember that Evelyn and Elizabeth Gomez talked about the fact that under the old system, regional centers would often be represented by lawyers, and people would come to a hearing and not be able to afford a lawyer, which felt really unfair. And that was one of our main goals in this legislation, was to change that. And it did change in October. So the way things work now is that a regional center cannot use a lawyer against you unless you also have a lawyer, to level the playing field. And that applies to an informal meeting or the mediation that Will just talked about, or the fair hearing. And unless you are yourself a lawyer or you have a lawyer with you, the regional center cannot be represented by a lawyer. You do have to give the regional center advance notice if you are bringing a lawyer to a mediation. That's 5 days advance notice, and you need to give them 15 days advance notice if you're bringing a lawyer to a fair hearing. But this is really one of the most important parts of the law in our view, because it does a lot to eliminate the kind of fear factor and the sense of intimidation that was really common in the old system. And again, this is already in effect today. What I'm going to talk about now are changes that are not in effect today, but are going to start taking effect in March, like the other ones that prior speakers talked about. So another important change that will take effect in March is that regional centers need to give you more information before the fair hearing, so you are in a better position to prepare. You have more information. So the regional center has to give you and the Office of Administrative Hearings, OAH, a written position statement 2 business days before the hearing. Okay, and this is new. A position statement really gives you the story that the regional center is going to tell about why they denied your services or denied eligibility. And they have to tell that story. They have to give you they have to describe beforehand what they're going to say in the hearing in some detail. They have to do it in your preferred language. They have to spell out the facts on which they base their decision, their denial of eligibility or services, and also the reasons behind that decision. Now, theoretically, under the old system, some of that information was supposed to be on the notice of action, which was mentioned before. But in reality, the notice of action often did not include that information. So now, not only should the notice of action include some information on the reason that a service was denied, but in addition to that, this position statement that you would receive 2 days before the hearing would give you additional information. And the other pieces of information that actually they had to provide before, and they will still have to provide, are information about their witnesses. Those are people that they're going to call to testify to support their case at the hearing. And also all of the documents that they're planning to use at the hearing. It could be communications, it could be expert reports, all communications. So all of those things, the regional center has to give you at least 2 business days before the hearing. And keep in mind that's 2 business days. So that could be more than 2 calendar days, depending on the date of the hearing. The other side of that is that also in March of 2023, you will also need to share information with the regional center. And if you do not have an attorney, then you will also need to share information with the regional center 2 business days before the hearing. Some of this is information that they have to share with you. You have to share with them a witness list. Those are the people that you're going to call to testify at the hearing to help support your case and how you know those people, who those witnesses are. And then the only other thing you have to provide is a copy of professional assessments or reports written by experts, right? So written documents like, for example, a doctor who did an assessment of a child, or some other kind of clinician who did an evaluation to decide someone's eligibility for services. Those kind of documents you do have to provide to the regional center at least 2 business days before the hearing. However, any other documents that you may want to use in the hearing, other than professional, assessments and reports, you do not have to provide in advance to the regional center. You can tell them at the hearing, you can tell them a day before, you can tell them whenever you want. Okay, so and again, this last piece about what you need to provide to the regional center, these are the rules that apply when you do not have a lawyer. If you have a lawyer, then your lawyer will kind of take over and you can trust them to know exactly what they need to do and when they need to do it. But the reason we feel this is a really positive thing, these 2 pieces together, is that you'll get more information before the hearing about how the regional center is planning to make their case.
This is you as well, Allison.
Oh, right. Okay. Yeah, I pretty much already talked about that.
Okay, good.
Yeah.
All right, good.
So I think it's in order.
Perfect.
Yeah.
Okay, Brian Capra, introduce yourself, please, and do the slide.
Well, good evening, everybody. My name is Brian Capra. I am a senior staff attorney at Public Counsel here in Los Angeles, California, and I am also a brother of a person served by the regional center system. So I want to talk to you a little bit today about another important component about the changes in the law that we saw. And this is called engaged neutrality. This is the concept of engaged neutrality. So let me tell you a little bit more about what that is. Essentially, the hearing officers now are going to help you get to the truth. Now, we remember Elizabeth talking earlier about her experiences that she saw firsthand, and countless more cases that she had heard from other families who had gone through the process. The law had always stated that the fair hearing process was an impartial process and it was an informal process. But that's not what we heard from Elizabeth. She said they were very formal. They said they were very, very intimidating. Do you remember the story that of Lulit's experience that she shared? The regional center spoke for 4 hours. Finally, she said, seemingly out of frustration, no, they didn't. And what happened? The judge said, you're not supposed to talk. And the judge was very upset. So that was the experience that many families endured. That perhaps is yet another basis for why there were so many withdrawn cases that Allison had shared earlier. So what can we expect now with the new change in law? Well, March 1st, 2023, we are going to have this concept called engaged neutrality. So what does that mean? The hearing officers must create an environment in which all relevant facts, both favorable and unfavorable, are brought out and to engage the parties to bring out the facts. So the concept is that the judge will be encouraging a free and open exchange of information and engaging the parties, being active, not being passive, not having the system hinge on the relative skill level of one party versus the other. And we know how that ended up with so many unrepresented families in the past. Now we're not going to have that dynamic anymore. The hearing officers will be trained on these principles of engaged neutrality. So let me tell you a little bit more about those. Okay, more about engaged neutrality. So how will this judge go about in this fact-finding mission to bring out the truth, to engage both parties and really have an emphasis on facilitating, eliciting, extracting relevant critical information that may help an unrepresented claimant or their family members trying to assist the consumer? How are we going to see that play out? Well, the hearing officers must see their job as helping you to identify the laws and facts that are relevant to your case. If you're nervous, you're unfocused, the hearing officers must not shut you down. Instead, the hearing officer must ask you questions to help you focus on what are the right things, to help out bring out the necessary the necessary information for your case that will enable the judge to make a full and fair record and to get to the truth and get to the appropriate decision in the case. Now, sometimes you're not going to have a piece of paper or a person, maybe there'll be something that comes up during the hearing and it'll be, oh shoot, I have that piece of paper. I didn't know that was, I hear what you're asking, Judge. I have that. It's at home though. It's not with me, or I have it elsewhere. I can get it to you. So now you have this concept where the judge can hold the record open and allow you to get that document. Or maybe it might be a person, somebody who knows the experience or was there to see what happened and could provide relevant testimony to help support you in your case. Now we have this concept where the judge can hold the record open to essentially pause the hearing to give you some time to get that document or to get that other person to come forward to help assist you in your case. So I think what we want to do now is to give you a sense of how this might look. We're going to try to do a little simulation for you all. So I think we'll all get started now on a mock hearing that hopefully will bring out some of these principles that I just mentioned.
I like, Brian, that you're calling it a mock hearing or a simulation. I'm calling it a Tony Award-winning performance of the advocate players. But we thought it would be fun for all of you. Well, it's really fun for us, but hopefully you'll have fun with us. For us to play the different parts of a hearing to show you what at least we hope you will experience when when this engaged neutrality goes into effect. And I'm hoping that Ed and Kira can spotlight all the cast members. I'll let you know who they are. Judge Brian Capra playing the administrative law judge, Elizabeth Gomez playing the mother, Miguel Lugo playing the self-advocate, Alice Morantz playing the friend, Maria Uriarte playing the former employer, Gilda playing the interpreter, and myself, I have the honor of playing the regional center representative. And I've been going into character recently for that. So, all right, we will get started. Judge Capra, you head it off.
Yes, good afternoon. My name is Judge Brian Capra, and I am an administrative law judge assigned to hear this case. We have here Miguel today because you have requested a hearing before an impartial judge. Today, we will hear testimony and see evidence. When we are done, I will prepare and publish a decision. But I want you to know that this hearing is going to be informal. I want you to feel comfortable, even though I know this can be a stressful situation. My goal today is to help get all the facts out there so I can make the most informed decision about your case. Do you understand what I just said, Miguel? Excuse me, Miguel, you're nodding. Can you please state yes or no for the record? It's very important that we have affirmative responses for the record.
Of course, Judge. Yes, sir.
Okay. I also know that we are having this hearing interpreted into Spanish when I speak and into English when all of you speak. Please let me know if there are any problems with the interpretation. Okay, so let's get started. Miguel, why don't you tell me why you're here?
Yes, hey there, Judge. Great to meet you. To be honest, I'm a little nervous here. I mean, I've had not so good experiences in the past regarding fair hearing, so I hope you will help me. I also brought my mom, a friend, and my former employer to help me as well.
Well, oh, excuse me, Miguel, I didn't apologize for interrupting. Go ahead.
No worries. I'm here because quiero trabajar, but I can't have a full-time job. I can't even have a part-time job with regular hours. I need lots of breaks. It's just way too much for me, and I get very anxious. I'm in a wheelchair. My spasms act up all the time. I need breaks. I think I just said that, didn't I? Oh, not last I was going to say it. Yeah, as I mentioned before, I'm a little nervous, Judge. That's why I brought my mom, my former employer, and my friend Allison with me today.
Okay, Miguel, thank you so much for introducing yourself. Would you like somebody else to explain why you were here?
Yes, I would. Amar, ¿les puede decir usted por qué estamos aquí?
Sí, mijo, claro que sí. Gracias. Sí, gracias, su señoría. Yo voy a tratar de ayudar, aunque también estoy nerviosa. Lo que pasa es que mi hijo realmente quiere un trabajo. pero lo único que el centro regional le ofrece es un programa de trabajo en grupo, los cuales a él no le gustan. El centro le ofrece únicamente trabajo en grupo y serían todos esos. Y esos son los trabajos que pues a Miguelito no quiere hacer. Él no quiere trabajos así como tales como trabajos en Marshall o Walmart. Sí, a Miguelito no le gusta separar ganchos. Ni tampoco le gusta trabajar con comida. Y él puede hacer mucho más que esto. Por esta razón le pedimos al centro regional empleo especializado. Yo escuché de este servicio de una amiga mía. Pero realmente yo no entiendo por qué nuestro centro regional dice que no le puede dar este servicio.
Regional Center Representative, could you tell me your side?
Yes, Your Honor. Thank you for having us today. We appreciate you giving us this opportunity. Through the Consumers Individual Program Plan held last October, the Regional Center denied the provision of employment services because the consumer has not exhausted the use of generic resources. According to Welfare and Institution Code, Section 4659, the Regional Center shall identify and pursue all possible sources of funding for consumers. These sources shall include, but not be limited to, the following.
Excuse me, Ms. Mark, let me interrupt you there. I don't think I need the law quoted right now. I want to get to the facts. Let me ask a question here, Miguel. Do you know what a generic resource is?
Not really. Ama, ¿usted sabe qué son generic resources?
Sí, claro que sí. Sí, claro que sí. Nosotros se lo pedimos al Departamento de Rehabilitación. Y ellos están peor. Dijeron que no pueden ayudar a Miguel tampoco. Me dijeron que él tiene muchas necesidades y que por eso no le pueden ayudar.
Did you get a letter in writing saying that they denied the service?
Se me hace que esa es la que se comió Firulais.
Yo creo que sí, hijo. Sí, claro que sí, pero tengo que encontrarla. En algún lugar la tengo. Y tengo otra copia en mi casa, pero mire, ¿sabe qué? Ya la encontré, sí, aquí está, y ya la encontré.
Okay, that's fine. This is certainly relevant. If you can email that letter to me and Miss Mark, the Regional Center representative, can you please do that?
Your Honor, I object to this documentation being provided. We did not get it in advance.
Well, it is relevant. And in the interest of justice, I am going to allow it. Ms. Mark, assuming that we get this denial letter in the next few days, what kind of services are you prepared to offer Miguel?
Yes, Your Honor. Well, we already told the parent several times that the only kind of employment services we have here at our regional center are group employment and supported employment in traditional kinds of jobs. We believe that this service is appropriate for Miguel.
Miguel, you said you brought your former employer with you today. Maybe she can share what she learned when you worked with her.
Sí, muchas gracias por preguntar y la oportunidad de hablar sobre Miguel. Mi nombre es María y Miguel trabajó en la oficina mía por varios años. Fue un gran empleado, nos ayudó con contestar los teléfonos, mantener nuestros papeles. También ayudó en la computadora respondiendo a los correos electrónicos de nuestros clientes. Pero vi que Miguel necesitaba tomar muchos descansos. Esto realmente no funcionó en mi oficina porque necesitamos a alguien quien conteste los teléfonos todo el tiempo. Creo que Miguel sería un gran empleado si pudiera encontrar un trabajo que le diera la flexibilidad que necesita en su horario. Muchas gracias por darme la oportunidad de hablar sobre Miguel.
Mira, creo que el empleo especializado es perfecto para Miguel. Quiero decir, simplemente no entiendo por qué el centro regional no se lo da.
I'm sorry, would you mind introducing yourself?
Sí, perdón, me llamo Allison y soy amiga de la familia. Y no sabía que podía ausentarme del trabajo para estar aquí hasta anoche.
Your Honor, I have to object to this witness. They were not on the witness list that we were provided 2 days ago.
Well, it is true that she's not on the witness list that was provided 2 days ago. But she just said on the record that she didn't know if she can be here until last night. Her testimony could be relevant, so I'm going to allow it. Go ahead, Allison.
Muchas gracias, juez. Mi hijo es muy parecido a Miguel. Necesita muchos descansos y a veces necesita un espacio tranquilo en su lugar de trabajo. En mi centro regional pudimos conseguir un empleo especializado para mi hijo. Y todos vivimos en el mismo estado, ¿verdad? No entiendo por qué los centros regionales no ofrecen los mismos servicios.
Your Honor, let me try to explain. At our regional center, we do not offer this service called customized employment. Most regional centers do not offer this type of service. So it just would not be available to him.
Do you have a service that might help support Miguel to have a job that meets his unique needs?
Well, we would require him to have an assessment, and then we would have to see what is recommended after the assessment.
Ya hemos hecho el asesoramiento. Y eso fue lo que recomendaron, empleo especializado. Yo se los mandé a ustedes hace ya 2 días.
Yeah, I see it here in your evidence packet. I will read it.
If you don't mind, Judge, you mentioned at the beginning that you were concerned about the translation, and I just wanted to mention that I'm bilingual, and I have been listening to the interpretation throughout this hearing, and I can tell you that it's really off. And I don't think that you're actually hearing everything that's being said by Miguel and his family.
Interpreter, have you been able to provide a professional level of interpretation during this hearing?
Yes, sir. But at one point, I couldn't really hear what was going on because I'm in my car and there was a lot of noise outside. I think I gave you the basic points.
Well, this is concerning. I may have to continue this hearing and make sure I have an accurate transcript and translation of this hearing. In the future, you should be in a place where you can pay full attention to the hearing and with privacy. Please let us know if you're able to continue providing interpretation today.
Yes, sir. I'm at home now and at my desk.
All right, I believe I heard from everyone. Miguel, is there anything else you would like me to know?
Not for myself, but perhaps from my mom.
Su señoría, yo quiero darle las gracias. Yo recuerdo que fui a una junta ya hace años atrás y cada vez que yo quería decir algo, el juez me ordenaba que me callara. Y ese juez fue bien estricto. Y aún yo recuerdo cuando le dijo a mi amiga, a la que yo llevaba ese día, que ella no podía hablar tampoco, que solo podía hacer preguntas.
Well, I'm here to get to the true facts of the case. I will hold the record open to receive the denial letter from the Department of Rehabilitation that you mentioned earlier. And I want you to send a copy to me and to Ms. Mark with the Regional Center. And I'm also going to be reading the transcript to see if we have an accurate count of the record. And with that, I will close this hearing.
We should take a bow. Thank you. Applause. Okay, go ahead, Brian. Why don't you talk about what might happen next?
Well, yeah, so the whole intent here was to show how things have changed from the dark days that Elizabeth and Luli described earlier. We really have to focus now on fact finding, making sure that the record is fully developed, fully and fairly developed, and that the judge can ask questions of the claimant. They can call a witness if necessary to come and testify. They can hold the record open to get a document or to have a person come forward if necessary. So in this particular case, maybe there would be certainly we want the Regional Center to have the opportunity to review the denial letter and to provide any response back. So probably what we would have done is held the record open for maybe 48 hours for Ms. Gomez to get the document over to us, and then giving the Regional Center another 48 hours for any response, for a response, if any. And then we would close the hearing at that point. Of course, I would also have to be looking at that transcript to make sure that all the information as we understood it was accurate.
Okay, well, thank you, the advocate players. I think we're gonna do a musical the next time, everybody. So we're gonna go back to sharing the screen and go and finish up our PowerPoint. And this next one, we're going back to Will now.
Thanks, Judy. I've been monitoring the chat, and you deserve all the Golden Globes, all the Oscars, and you said music, all the Tonys too. Right? Let's talk about what happens if you want to fight a bad hearing decision. I mean, we all liked Judge Capper, right? He treated Miguel fairly. He helped make sure that all the facts came to light. And he made sure that everything was being interpreted properly. But that doesn't always mean that he's going to rule in Miguel's favor. So I'm going to talk about what happens when you think the hearing officer got it wrong. Under current law, if you want to fight a bad hearing decision, the only way to do this is to file a case in Superior Court. This type of case is called a writ of administrative mandate. The timelines are really fast. You only have 90 days to decide whether to fight the case in court. And this is something that you need a lawyer to do. But with the new law starting on March 1st, if you think the decision made factual errors or legal errors, you can ask for something called reconsideration within 15 days after you get the hearing decision. Reconsideration, it's kind of like a second chance. For example, maybe you think the hearing officer completely misstated what the law says. or ignored a really important assessment that talks about the need for a service, or maybe the hearing officer just made a mistake and got a really important date wrong, and you lost your case because of it. Now you can do reconsideration. And if you ask for reconsideration, the second chance, a different officer will review that request. It will not be the same hearing officer that decided your case. And when this happens, if you make this request, one of three things can happen. The hearing officer can deny your request, in which case the original hearing decision will stand. The second thing that can happen is that your request will be granted and there will be a new hearing. Or the third thing that might happen is your request will be granted and you'll get a new written hearing decision without the need for a new hearing. The law says that if you want to ask for reconsideration, you can't just say, I want reconsideration. You also need to state the specific reasons why you think there was a factual or legal mistake. But the most important thing to stress here is you don't have to do this in court. You don't need a lawyer to do it. It's something that you will submit to OAH and a different hearing officer will receive it. Lastly, you still can file a case in Superior Court if you want, but instead of only having 90 days to make this really difficult and possibly very costly decision, now you'll have 180 days. You'll have much more time. Now let's talk about what happens if you can't get a regional center to comply with the hearing officer's decision. Remember Margot? She won her hearing, but then the regional center didn't comply with the order. Then neither DDS or OAH said they would or could help. She ended up spending $20,000 on legal fees for $10,000 worth of services. Well, with the new law starting March 1st, there will be more oversight and accountability when regional centers don't comply, when they don't do what the hearing officer ordered. So now if the regional center can't implement the hearing decision within 30 days, it must tell you and DDS and explain all of the reasons that can't be implemented. And it can't just be any reason. There must be specific exceptional circumstances that make it impossible to implement the decision in that time frame. And the regional center must also provide you and DDS with a date by when the decision will be implemented. And if you're unhappy or dissatisfied with how long the regional center is taking to comply with the hearing decision, or anything else about the regional center's compliance with that decision, you also now have a right to contact DDS, and DDS must then take what the law says appropriate action to get the regional center to comply with the decision.
If I could ask folks who have the skill and capacity to write all over our slides to refrain from doing that. I don't even know how one does that, but let me see what happens when, okay, so I'm gonna have to stop sharing the screen and then go back to sharing the screen probably to get rid of those lines. Yes. Okay, so please, I don't even know how one does that, but please don't do that. Thank you. This is Vivian. Go ahead, Vivian, please introduce yourself first.
Thanks, Judy. I am so grateful to be here with all of you tonight. My name is Vivian Hahn. I am an attorney with Disability Rights California. I also have a brother who has autism and is served by the Eastern Los Angeles Regional Center. So when our coalition first started working on this law, we knew that creating a fairer hearing system would need to start with listening to the people it serves, which means making sure that people served by regional centers and their families have ways to share their experiences with hearing officers and the Office of Administrative Hearings, so they can trust that hearing officers are hearing them and have at least some understanding and background about who they are, what issues they face, and what their lives are like. So first, one of the most important changes in this new law is better training for hearing officers. And part of that will be that hearing officers will be receiving more trainings on some of the things that we just saw earlier in the skit around engaged neutrality, which really means that hearing officers will get training on how to create a good hearing environment, one that's welcoming and that's patient and that's designed to help people who don't have lawyers and to be more supportive of people who may be going through this for the first time or might be unfamiliar with the hearing process. So that's a really important piece. One of the other things that we advocated for was for hearing officer training on how to make hearings more accessible for people with disabilities. At DRC, we had heard over the years about hearing officers who sometimes seemed impatient with someone with an intellectual disability, who talked over them or maybe seemed unfamiliar with how to interact with them. Which is why we advocated for hearing officers to get more and better training about how to work with people with intellectual and developmental disabilities, specifically people who might need things explained to them in smaller steps or with simpler language, or who might have other unique communication needs, as just one example. Next slide. In addition, there will also now be a committee for the specific purpose of advising the Office of Administrative Hearings on how to improve hearing procedures. Now, other hearing systems have had this kind of advisory committee for a long time. The Office of Administrative Hearings, OAH, had already had this kind of committee for its special education hearings. And in these advisory committees, typically both sides, both the regional center and the representatives, as well as people served by the regional center and their family members, both sides would be meeting with the hearing office to discuss everyday in the weeds problems like scheduling, calendaring, uploading documents, where and how to submit those documents or how to make requests, technology issues, the real life everyday things that can really be a huge barrier to being able to access a fair hearing if you don't have anyone to help you or to explain how those details should work. That's why having this kind of regular feedback loop with the Office of Administrative Hearings, we think makes a lot of sense, especially as all of these new changes are being rolled out. We do expect there to be maybe a few bumps since everything is very new and everyone in the system is going to be learning. So to have this kind of committee where people who are directly impacted by the hearing process can give feedback to the Office of Administrative Hearings in real time, we think and hope will be very helpful. We've been told that there were a large number of people, and probably some of you, who applied to participate on this advisory committee, which to us shows that there's been a real hunger for people to have a real voice, real input, and a seat at the table when it comes to the processes that directly affect their lives. And we thank the author of Senate Bill SB 1092, Senator Melissa Hurtado, and the Senate Human Services Committee staff from last year, as well as DDS, for their support and collaboration in making these changes possible.
Thanks, Vivian. Well, speaking of DDS, they are next. As I want to echo what Vivian said, we are very grateful to our partnership and our working relationship with the Department of Developmental Services with Nancy Bargeman, Director. And these two particular individuals who have been meeting with us regularly to ensure that the implementation is going well. So I'd now like to introduce Pete Chervinka, the Chief of Data Analytics and Strategy. And he's like I don't know, you've got to be bigger than that. I think you have some bigger title than that. But and Katie Hornberger, who's the acting DDS ombudsperson, as well as a consultant to DDS around these and other issues. And I am going to stop sharing my slides because they have their own slides. And thank you so much for coming, Pete and Katie.
Thank you for having us. So I'm going to lead us off and I'll be sharing my screen. So, it's kind of an effort in my technical abilities.
We are not yet seeing the slide, Katie.
Horrible beeping noise. Is anyone else hearing it?
Yes.
I am, yes.
Okay, the beeping stopped. Nope, it's back.
I have your slides. Do you want me to try to share them?
Sure.
Okay.
Maybe I think the beeping stopped too.
I have them right here. We're always ready to go if needed. Okay, so now, well, hold on. Now I can't find the way to share it. Okay, share screen. Okay. Share and play from start. Okay, there you go. Just tell me when you want to switch the slide.
Okay, so everyone is frozen for me. Do you still hear the horrible beeping?
We hear beeping. But we can hear you fine.
You can hear me fine? I can talk over a beep. Over worse. So
Are people not seeing my slides? I see something in the chat that nobody's seeing the slides.
Katie. Folks, you're going to have to go at the top to view options, shared screens, select Judy's share screen. I have to also let you know, Judy, that I cannot hear Katie over the beeping, and I'm sure our interpreters are having trouble as well.
Katie, you need to stop sharing your screen.
It's not letting me do anything. But you know what I'm going to do is I'm going to try and just hang up and rejoin because it's weird. It doesn't let me do anything.
Okay, yeah, I would get out and come back in. Okay, there we go. All right, so Pete, you may be having to carry this off here.
Get up and run until she can get back in.
Okay.
Apologies, folks.
Okay. Are you just seeing the slide and not the notes?
Correct.
Okay, great.
So thank you, everybody, for having us. Really appreciate your engagement tonight in this vital discussion. The fact we have 375 people here at one point is really testament to the interest in the community for this. And the department, on behalf of Director Bargeman, really appreciates the opportunity to be here. Katie, you're back, so I'm going to give you a chance to say hi.
Hi.
No beeping and it's clear. You want to take it?
Sure. So as I suspect Pete was starting to say, the department, I came in August of 2021 and they already had efforts underway to look at the appeals process and to make changes to it. And so those of you who know me can guess that I immediately was like, I want to work on that because I saw a lot of opportunity for us to really improve this process. And so, after I came, we started meeting with groups of people, we conducted a survey, and frankly, we came up with lots of places to improve the process. And so we have a number of intended outcomes. And luckily, those really aligned with the things that all of you and folks in the advocacy community were also saying that we needed to change. And so, it fell into a few buckets for us. The first one was really about information and training and having information available in people's preferred languages. California is an extremely diverse state, and we have to make sure that people have information that they can understand. And that also means not necessarily just printed language. And the other thing is when we look across the state, I tried to collect all 21 of the regional centers' appeals information packets that they were sending to families, and they varied significantly. And that makes it hard for people to get support from their friends and colleagues in other areas of the state. And so we really thought about how do we standardize information and forms and put things in formats that people can understand and work with. We also wanted to reduce burdens. You've heard many of the speakers talk about all of the things that people have going on in their lives. The fact that you're able to join us at the dinner hour and have this many people joining us is really a testament to how interested that you are in this topic, because you all have other things you could be doing right now. And so we need to reduce the burdens on people who are trying to appeal a decision. That means more opportunity for informal resolution, expanding the timelines, making sure that we have clear communication and document requirements, and then standardizing forms and template letters so that people can really understand them. Next slide. The next thing that we wanted to do is, thinking about fairness. The regional centers, they do this for a living. It is their job. And I say that as I'm a lawyer. You are not lawyers. You are family members. You are caregivers. You are allies. You are not legally trained. And so reducing the formality of mediations and hearings was important to us. Improving the quality of translation and interpretation so that people have the information that they need, and really maximizing opportunities to get out the facts on both sides. In the skit, you saw Hearing Officer Capra asking people and sometimes interrupting and saying, wait, no, I need to understand this. Tell me more. And that's really, and working with the Office of Administrative Hearings, really working on this concept of engaged neutrality, and that for them to make a decision, they need to have all of the facts. And maybe that they need to ask questions, they may need to call witnesses, they may need to expand the time of the hearing, leave the record open, but they really need to secure all of the facts and information before they make a decision. The other thing is, you heard mentioned that there is no data on why people withdraw. I love data. I'm one of those people who can go down the rabbit hole of data. And I will tell you, I was surprised at some of the data we didn't have here at DDS when I came here. And so in the trailer bill, we've enhanced what we're going to be collecting. Part of that is also trying to make more things electronic to make that easier and faster. And so trying to, we're developing things like an electronic appeals request form so that you don't have to fill out the form and mail it back to your regional center or fax it back. Instead, you'll go online, complete the form online, press submit, off you go. The other, we had someone talk about their inability to get their hearing implemented. This is another place where we saw an opportunity for really using, our website to work to help that. And so one of the things, the law says that the regional center has to implement a hearing decision within 30 days, unless there are exceptional circumstances. And if there are exceptional circumstances, they need to send you and DDS a letter explaining those circumstances and when they believe the hearing decision will be implemented. and that you can get help from DDS. And so we have an electronic form that you can submit online if you need help getting a hearing decision implemented. Because the reality is, I know what your lives are like, and let's be honest, you're filling out forms at like midnight after the kids have gone to bed, because that's the only peace and quiet that you have to get those tasks done. So now you can do all of those kinds of things online. So March 1st really is going to be an opportunity to make things easier, to do better data collection. And then once we have that data, then we can publish and analyze trends of what we're seeing. And some of that can be in the, at different levels. We can look at regional centers. We can look at areas of the state. We can drill down on ethnicity. The more data we have, the more information that we have, and the more we can make effective changes in the future. Next slide. So how do we make all this happen? We made all of these changes to the law. I believe in changes to the law, but the reality is we have to do a cultural change with it. And so we have been working on training the Office of Administrative Hearings. We've trained regional centers, hearing staff. We're going to be working on training additional regional center staff. And part of that training is thinking about this as not just a hearing. It's an appeals process, because very few people go to hearing. Most are actually resolved early. And that's what we want. We want them to resolve early, because you ask for eligibility or a service because you needed it. And so we want to resolve it quickly, get you the services and supports that you need. And so really focusing on the process, resolving things early on, utilizing online forms so that people can do so more easily and more quickly. Of course, for people that want to use paper forms, that's still available. You can fax information, you can email it, you can call us. We will be able to accept things in all of those modalities to meet everyone's needs. We're standardizing more things, and that will help both the regional centers, because we'll be giving them the forms to use in all of the languages. And it will help all of you so that when you try to get help from your friends and people that you know, even if they live in a different area of the state, things will look the same as what they receive from their regional center. When Judy introduced me, she introduced me as the acting ombudsperson. And when I first came to the department, I opened the Office of the Self-Determination Program Ombudsperson. And then December 1st of 2022, just 2 months ago, we opened the Office of the Ombudsperson for Lanterman issues. And we actually see the appeals process as a place that staff can be really helpful. And so really what all of this is driving is better experiences and better outcomes. And, how are we going to know if we're successful? Right? We've got all these great goals, we changed the law, but is it going to work? I'm going to turn it over to Pete to tell you how we're going to find out.
Thank you, Katie. So March 1 is approaching. And as you've heard today, all of you are the reason that these changes are happening. It's a very collaborative effort, and many of the groups sponsoring tonight's event contributed to the development of the changes in the law that make it better for all of us. March 1 is not a magic light switch. We know that not everything will be perfect. We are committed as a department and as a system to continuing to listen and learn and improve and make those changes going forward. There will be ongoing opportunities for input, particularly from people going through this process, but also with people who still may have reservations about using the process. We are also updating the surveys that we provide to people after they experience mediations and hearings, so that we collect information about how the hearings were conducted. I want to applaud the acting jobs that were done earlier in the skit as well. Add me to the list of 70 people clapping and waving. And then there are also formal opportunities for that. And previously mentioned, the Lanterman Hearings Advisory Committee will be newly created. We took applications for initial membership in that group through the end of January, and had several hundred folks express interest. And we will be going through those too. So, I think I want to close by reiterating, I have yet to meet a system operated by a government that everybody loves and thinks is perfect. But it doesn't mean we can't try to get there. And people can't fix what they don't hear is broken. And we can't improve things even when they're already good, without hearing from people about those things too. And so I think, although the statutory changes came as a result of a lot of partnership and state budget investments, I think those partnerships and those communication opportunities will continue into the future. We want to continue to hear from people. We are trying, and Katie, thank you for going through kind of the list of things we're doing on online forms, faster communication, more time to make your decisions. All of these things should make this process much more approachable and usable for people. I saw several notes in the chat that I'll take a moment and respond to as well. A number of people have said that only people with the resources or the capacity to use this process have been using it. We are very interested in learning who's using the process and who's not using the process. And not just at the hearing stage, but from the informal meeting, mediation, and the hearing process. We're going to be collecting information, and it's required by law because we thought that that would be good, and others agreed with us. The issue or issues involved in the case. Why is somebody appealing? We're collecting language and age information. We're collecting other demographic information as well. For informal hearings, we're also getting a copy of the notice of resolution. Kind of how was the issue decided, so that we can look at the outcome of those. For mediations and hearings, we're also looking at whether an issue is withdrawn and why it's withdrawn. The issues that go even further in this process and why. Also here the outcomes. We're also going to get copies of the mediation agreement or the hearing decision. We're also going to be tracking the time it takes to go through each step of the process. And of course, demographics through all of it. So we're very interested that this process be called the appeals process, and that we never hear it become the unfair appeals process. We want this to work. We know that it can get better. And again, just really grateful for all of the hours and hours of time that people have spent collaborating to this. But it really is the experience of folks using this process that enables all of us to make it better. And so if you have a good experience, please share that. If you have a mediocre experience, please share that with us. If you have a bad experience, please share that with us, because it can only make it better for the people that might follow you later on. So thank you for the opportunity to be here tonight. On behalf of the department, we are really committed to making this as good as it can be. And we know that it's a process. So please, on March 2nd, if you're going to call me, know that I expect calls saying that wasn't a good experience on March 2 and 3. That will definitely happen, but we will get through that together. Thank you.
Thank you, Pete, Katie. Also a shout out to Catherine Blakemore, who's in the audience, for all your hard work at DDS on making this successful. Okay, so I just realized I need to get back to the other. We're going back to this. We have just a few more slides, and then we're going to take as many questions as we can. We will not We will go till 7. We have the interpreters till 7. So we will get through your questions. Wait, why did I go to the beginning? Hold on, that was bad. Hold on, I need to go all the way to the end. This one, there we go. So there are organizations who are co-sponsoring this event, who are going to be monitoring how it's working. And we just want to tell you a few really cool ways that we are doing that. So we're going to start with Disability Rights California, Shannon and Maria.
Hi again, everyone. This is Shannon. I'm going to talk quickly about the Office of Clients' Rights Advocacy. You may know us as OCRA. You may know us as OCRA. You can call us whatever you want. Just call us. I'm going to help you find us by putting links to our staff contact information in the chat. We're a program at Disability Rights California. We have both advocates and attorneys to help people with regional center services and with generic resources. So those generic resources are things like Social Security, special education, IHSS. So we can help people by representing them at hearings. We can give them advice about their problem and how it might be resolved. We can give them information. And we have advocates and attorneys assigned statewide for clients of all of the regional centers. And I will turn it over to Maria.
Thank you, Shannon. My name is Maria Iriarte, and I'm an attorney with Disability Rights California. Thank you so much for being here tonight. It's really important to all of us. So in response to our community, Disability Rights California created the Fair Hearing Project with the primary focus of representing monolingual Spanish-speaking regional center consumers at administrative hearings before Office of Administrative Hearings. I know that you guys probably have a question of how do you guys reach us? So the way that we're doing this is that you can call our pre-intake line, and the number is there, 800-776-5746. So a person from this unit will talk to you about your concerns and do a conflicts check. We want to make sure that you're not working already with someone from the Office of Clients' Rights Advocacy. So if there's no conflicts checked, we will put you in the queue and you will then talk to an advocate. That advocate is going to create a file. We call it a service request and provide counsel and advice. A list of these service requests are created every week, and it's reviewed by our staff to provide any further feedback and also to identify any potential cases where we may want to represent. So that's the way you would do it. Call our pre-intake line, it's there.
Thank you so much, DRC. And now we're going to move on to a group that some of you, why does it keep going? Something is happening, and I apologize. Now we're going to go to a group that some of you may not have heard of before, the Legal Aid Association of California, or LAC. So Lauren, can you introduce yourself and talk a little bit about your organization?
Hi, everyone. My name is Lauren Klein, and I am the Director of Advocacy at the Legal Aid Association of California. We work with over 100 legal aid organizations across the state. So if you haven't heard of legal aid before, a legal aid organization is a nonprofit that provides free legal help, so no charge, to low-income people, seniors, and people with disabilities. Like I said, there's 100 of these organizations across the state. We are grateful to have had the opportunity to work with our partner organizations to get these changes to the law, and we're optimistic that it will make the process fairer and easier for you all. But we do hear you that you still want help. You still want more attorneys available to represent you, to give you advice in this process. So that is our goal here, is to make more legal aid attorneys available to help. So we are working on that already. One good thing is that this fair hearing reform process has brought more attention to this issue. Right now, not that many legal aid attorneys in the state do this kind of work. Disability Rights California, of course, does amazing work representing encouraging and advising folks, but most other legal aid attorneys don't know about this work. So we're going to take advantage of the fact that more attention is here, and we're working on recruiting more legal aid attorneys and training them so that they'll be prepared to help you through this process. We're getting started on that now, and we will be sure to let the community know as we get more legal aid attorneys on board how and where you can contact them for help.
Thank you, Lauren. Okay, so I apologize on behalf of Allison, whose internet went out, and she cannot get back in, unfortunately. So unless she's in a waiting room, I don't know if you guys have seen Allison or anybody coming in, but I don't see her. All right, I'm just going to briefly talk about what she would have said. Allison created a project within Stanford Law School called the Stanford Intellectual and Developmental Disabilities Law and Policy Project, or it's a very long name because these are lawyers, and it's called CIDLAP for short. And CIDLAP, if you should absolutely go to their website, and if you just Google CIDLAP, they have done some absolutely incredible reports, and they also have this amazing search tool on their website called the Lanterman Fair Hearing Smart Search Tool. So if any of you out there are disability rights, OCRA folks, if you are advocates that help people, if you are community-based organizations who help people at fair hearings, you want to use this smart search tool. You can go in there, it's right on the main page right now. And I was interested in seeing what kind of fair hearings there have been around the self-determination program. And it brought a whole bunch up, and I could see the way that judges were ruling on it to see if we had any concerns or if they were right or wrong. So in our opinion, of course. So there's lots of resources there. And the other thing that she was going to mention is Rad Justice, which is a group of Stanford law students. So these are really, really smart people who are sitting in on some people's fair hearings to monitor how it's going. So amazing work at Stanford Law School, and sorry that she got shut off there. All right, let's go to Elizabeth Gomez. Go ahead, Elizabeth. Oh, no, this is Fernando. I apologize. Fernando Gomez.
It's the other Gomez.
Gomez.
Thank you, Judy. And so Fernando Gomez, co-founder of the Integrated Community Collaborative, along with Elizabeth, as she introduced herself earlier. We do have a son who's served by the Regional Center system. But I want to talk a little bit about how we plan to collect data and help provide some of this data to the department and other entities who are helping with this, what we're calling the Fair Hearing Reform, or now is called the appeals process. In this previous slide, Judy talked about CIDLAP, and the last point was Rad Justice. Rad Justice is a program that we've been collaborating with as the ICC in Stanford, where, and I know some of you, the volunteer students are here tonight in this town hall. And what we do is we've been working together to help provide insight and help provide observations from when our families that we help support go through the fair hearing process. So what we wanted to do is take the Rad Justice one step further as it comes now to this appeals, the new appeals process. And Pete was right when he said, you know, come March 1st, you're just not going to flip a switch, spread some pixie dust all over the place, and everything is just going to be hunky-dory. It's going to be a process. And we've already seen a lot of the new elements that were introduced start implementing. Come March 1st, we're going to see a lot more. And from we as an organization, what we've experienced with a lot of the families that we've helped through the process, and what I'm also reading in the chats, it hasn't been a pleasant experience, and it's been extremely challenging and difficult. And everything that's being said is Absolutely, we completely understand. That is why we're having this fair hearing town hall today, to say that this is going to change, and it's going to change gradually, but we're going to start implementing the process as best, as what Pete said, committed to making it as good as can be. But to be as good as can be, it takes all of us to work together as a community, not only the organizations that are represented here today, but each one of you who's here tonight, to be able to say, how do I take my experience, my perspective, my feelings, and be able to contribute to this new changes. So what we're saying here today is that ICC, coming back to CIDLAP and Red Justice, is going to look back at how, when you go through a hearing, the experience has been based on all of these new statutes that are being introduced. We're also going to go back 7 years and look at the hearings and the process, take that information, share it with DDS as best possible to see what, to reinforce a lot of the elements that brought these new changes, but also compare it to what's going to happen going forward. So that's going to require, of course, permission from those of you who have been in the hearings and are willing to participate. And of course, there's a process of making sure that, the private information is kept confidential and so forth. What we want to look at is the outcome, the experience, and the elements that came into play. There was something that was mentioned earlier in the presentation that referred to engaged neutrality. Engaged neutrality is the ability to have not only that fair hearing process, but you feel like you're an equal partner in that, not only the representation, but how that whole thing plays out. So those are the things that we're going to look at as well in capturing this data, especially with the hearings that we're looking at going forward, to say, is engaged neutrality being implemented, through these trainings from the judges to the regional center staff? Is that really working, and has that really taken hold of what they're being trained on? So this is all part of the process where everybody's trying to do their part. The ICC, in collaboration with CIDLAP and the Red Justice Program, we're looking to say, here is this data, here is the feedback coming straight from the community, firsthand experience, and let's see how does it make it to improve the system. So we're really excited to work with that. And at the same time, we're really excited to work with you. So if you received an NOA or have been through this process in the past and you're willing to participate in the study, please let us know. You have my email address there, info@iccintegradora.org, and we'll be happy to include you. And then if you are going through the process, or you're thinking about going through the process and you need some help, better understanding and looking what some of your options are, we do have what we call an open sessions during the week. Send me an email and I'll provide you more information on how we can help you connect with that. We're not attorneys, we're not social workers. We are just parents and self-advocates helping other parents and self-advocates navigate the system. Thank you very much.
Thanks, Fernando. This is our last slide, and we'll have sorry, this has gone on so long, we had a lot to cover. But if you want to also tell DVU about how you're experiencing the appeals process, we're just collecting information as opposed to the ICC, which is really processing the information in a much more comprehensive way. But we've created an email address of fairhearings@dvunited.org. Please feel free to email us. We will not be able to represent you, but we can forward your email to those who may be able to help you. Always encourage you to contact your legislators if you have any questions. If you don't know who your state legislators are, you can go to findyourrep.legislature.ca.gov to find out who that is, and they're there to serve you. So we're now moving on to the little time. We have about 15 minutes, and I apologize. We had a lot to cover, and we'll probably come back and do this again in a few months. I know we've had a lot of people with hands up. We're going to have to go back and forth between hands and questions in the chat. Ed, can you give us like the most compelling questions that you've had? And I will throw the questions to folks to answer and I'm going to ask you to answer them in just a minute or 1 or 2 minutes. Ed, are you ready, or should I go to a person? Oh, Ed, are you there? I am not. Oh, Ed is here. I am not hearing you, Ed.
Can you not hear me?
Oh, now I can hear you.
Okay, Judy, why don't you, I was just saying, I'm gonna highlight some and then read them to you. Why don't you go to Brian or to whoever has their hand up
Okay.
and then pop back to me?
Okay, Brian Allen, do you want to ask a question? We're going to ask you to keep your questions very brief, please.
Yeah, good evening. Brian Allen, educational consultant advocate. I assist families at our regional center. My question is regarding the hearing reform that's supposed to be effective March 1st of 2023. How is this going to be effective, and did it pass? SB 1092, did that pass? Because according to my Google research, SB 92 did not get signed by the governor. So what does that mean?
It's a great question. I'll just answer it very briefly. So Senate Bill 1092 did not pass, but what happened is that many of the provisions, not all of them, but many of the provisions got folded into the state budget. That happens sometimes in the state of California. It actually happens a lot of times in the state of California. So it was folded into the state budget. And so all the reforms we're talking about today were part of SB 1092 but ended up getting put into the state budget bill as opposed to being passed as a regular piece of legislation. So the answer is yes, but there were some things that we had asked for that didn't get placed in the budget. We're not prepared to go back and ask for them again yet, but we'll see how it goes after this law takes effect. Lourdes, go ahead. I've asked you to unmute.
I was wondering, how is it that, what happens with the fair hearings that, they're going to expire during this time until March 1st? When is the deadline for counting backwards on the date? Or does it start on a hard limit on March 1st?
So I don't know if you want to come on and explain the start date, but it doesn't go back in time and change what's already happened. When the law goes into effect, it's only for those hearings that will take place from March 1st on. Do I have that right, Will? Or Brian? Any lawyers want to confirm this?
Some of the law, this is Brian, some of the law had specific provisions that provided for an effective date of October 1st. But most of them will happen on March 1st, 2023, and there would be no retroactive application with respect to the majority of the effective changes coming forward in the next couple weeks.
Thanks, Brian. Ed, do you want to ask a question from the chat?
I certainly do. Can you hear me?
Yes.
Great. Just making sure. Hold on one second. I want to make sure our spotlights are correct. Great. So I have a question from Valerie Vanneman that is addressed to the folks at DDS. Doesn't the new law say that the director of DDS can decide to take over a case and make a decision outside of any hearing, and that you won't know that occurred until the hearing is done?
No, I'm going to give a very brief answer, and I'm not a lawyer. So what the law requires is that the Office of Administrative Hearings conduct a hearing. The director, like directors for other state departments, generally delegate 100% of their final decision-making authority to those ALJs. This law simply creates the same structure that exists for other departments, in which on some topics, the ALJ's decision will not be considered a final hearing. It will be considered a final decision. It will be considered a proposed decision. And the director of the department may, in those instances, review that decision. This we expect to be not used very frequently. But for example, and we've seen comments in the chat today, for example, the department just rolled out a new policy, a new service called Coordinated Family Supports. And so it's possible that while we're training ALJs on what that program is and what's allowed as a service in it, that for some period of time, we may want to review any decisions on that topic, just to make sure that we're getting our training right and that ALJs are deciding cases consistent with that new service. But this is not random. It's the director has to delegate his or her decisions to the Office of Administrative Hearings. So we think it's a minor point and it's not random. It's known in advance which cases the director has decided to delegate or not delegate. That decision hasn't been yet made, but it will be. And if it's not done publicly by March 1st, then current law would continue, in which case that means 100% of ALJ hearing decisions are considered final decisions. So there is no director review at all until she decides that she wants to see something. Our director's a woman. For those who...
So here's my view on that, just really quickly. 95% of cases are either withdrawn or decided in favor of the regional center. So it's not like this was part of the law that we got passed. We're not trying to get the other 5% to be ruled in favor of the regional center. This was to say that of those that actually go and get ruled in favor of the regional center, that there is someone looking out for us. And, some may not believe that DDS is going to look out for us, but at least DDS is accountable to us, right? DDS is appointed by the governor and the governor is elected by us. And so we feel, and it works well in other systems, in other departments in the state, we feel that this is a really good opportunity in some rare circumstances that we can say, you know what? The ALJ ruled against the person. We think that somebody needs to look at this, and we now have that opportunity to try to make that happen. So we think that this is not a way for DDS to now rule more against people. That's not the goal here. The goal here is to make sure that things are right, that we get all of these right.
Yeah, thanks, Judy. If I can add to my answer, I would also say, remember what I said about data collection in my initial remarks tonight. We are collecting information about outcomes at informal meetings, at mediations, and at the hearings. We are looking at the timelines for those things, and we're looking at the reasons why things were withdrawn. So we're doing a lot of data collection under this new law that we did not previously do. I would additionally add that as a practice, because the Department of General Services, which operates the Office of Administrative Hearings, which employs all the ALJs for mediations and hearings, they are funded under a contract from the department. In our role overseeing that contract, we're both required to do the training for the ALJs or ensure they have adequate, appropriate material for that training. But we also receive copies of their decisions, and we have people who review those decisions as well. So the director's authority to review a proposed decision is not the only thing that we're doing to ensure that things are being done better than we've heard tonight they have been historically.
Thank you, Pete. Ed, why don't you throw out another question?
Didn't realize I was muted. I can certainly do that. One moment. Let's go to a question from Savannah, or excuse me, I beg your pardon, Sabina. Golden Gate Regional Center often uses the quote, "The regional center cannot supplant the services that other agencies are supposed to provide within the context of a fair hearing." They get away with that time and again, even though they are and should be the payer of last resort. Is it possible to demand more information? Am I allowed to do that?
I don't know if Vivian or Will want to try to answer that question. I think this is about generic resources, if I had to interpret it correctly. Will, Vivian, would you like to take that?
Yeah, this is Will. I can take that. It's a good question, and I hear it around generic resources, a decision about that in the context of a hearing. So a regional center says, not us, you have to get a service elsewhere. They can't, that, I would say that that would be inadequate for something that would go in a notice of action. You'll now have the right to get a position statement from the regional center before the hearing, where they have to talk about all the facts, what generic resource they think is available to you, the circumstances, why they think it's available. So yes, you have a right to demand more information. And under this new law, they have to give you more information about why they made their decision. And a one line about generic resources isn't gonna cut it.
Thanks, Will. Helpful. Let's go to a quick question. Lisa, Lisa Walker, can you keep it real short?
Yes, thank you. Just want to say that when my daughter, I'm trying to transition to SDP. Before the SDP, I went through IPP, and we talked about the unmet needs. And at the time, the service coordinator and program manager was unable to make any decision at all. And they said they have to consult with the legal team. So their legal team consists of a lawyer, the director of a legal department, director of a case coordinator, and the coordinator. And these are the legal team. I'm talking about regional center top dog. And four of them are having discussion how to deny services for child who has ASD, epilepsy, cerebral palsy, and ID. And they said that when my daughter is nonverbal, ask for communication and ask for the parent training, they sent me a denial saying that the parent is trying to increase the SDP budget, and therefore my daughter does not need to communicate, basically. And they send me all this legal section. What I'm trying to say, with this new law, they're front loading all their acts before they send the NOA. And therefore, when they go, they're training their staff before, and they're cherry picking all this family member to deny.
Right. So Lisa, I'm sorry, but I want to try to get an answer to your question before we have to leave. Unfortunately, at 7, because that's when our interpreters leave. I'll just take it real quick. This is a concern that we have heard from many people. In the original SB 1092 legislation, we did try to address this. The fact that that the IPP team is not actually making the decisions in the for people services, that it is made by some, what I call a secret committee of people who don't even know the individual. We did not get that. We did not get those pieces out of the law. So we may be going back in the future, but we want to hear those stories. The DDS ombudsperson will want to hear those stories. Pete will want to hear those stories. So let's keep. There's a lot of people saying in the chat that they all hear that all the cases are decided for services behind closed doors. So that is something that we will continue to monitor. And I want to first apologize that we did not have a lot of time for questions, and perhaps DVU will try to rehost something like this to get a lot of these questions answered, everybody. I really apologize. We had a very long training, so maybe we'll do this without a training and just answer a whole bunch of questions. Thank you to all of our speakers, to DDS for coming, Pete and Katie, to all of our advocate players, and our performances will win awards. So thank you all for coming today. Again, apologies we couldn't get to all your questions. We will do a do-over, we promise, and we'll get to them in the future. Thanks, everybody. I'm going to say goodbye a few times before we cut you off. before we end this to make sure that the interpreters have a chance to catch up.